A court of appeal in Abuja has clarified that Section 84, subsection 12 of the Electoral Act of 2022 is unconstitutional because it denies a class of Nigerian citizens their rights to participate in election. In a judgment on Wednesday, Justice Hama Barka set aside the judgment of the Federal High Court in Umuahia, which voided the section of the law, saying the court had no jurisdiction to have entertained the case. The judge also added that the plaintiff, Nduka Edede, lacked the locus standi to have filed the suit in the first place because he did not establish that he was directly affected by the provision. Well, to help us make sense of the appeal court's judgment, we are now being joined by Monday Ubani, who is a legal practitioner. Well, thank you for joining us on the news. Now, help us understand the appeal court's judgment, because in one breath, the panel of judges set aside the decision of the lower court saying it lacked jurisdiction to hear the case. And in another breath, it ruled that Section 8412 of the Electoral Act is unconstitutional, which was the same ruling the Federal High Court delivered. Now, how would you interpret this judgment?
Yes, to the unlearned mind, it creates some level of confusion as to what the court was trying to say. In one breath, and in another breath, a different thing was reached by way of decision. Now, what happened, and the way I understand that particular case, that took place at the Court of Appeal, is that the court held in one breath that the man who sued as the plaintiff in that case at the lower court had no locus. If you look at the Electoral Act, it specifies the person that is qualified to bring any action against the provision of that Electoral Act. And he must be a contestant to the position, that you are actually quarreling with. He must be an aspirant, to a political position before you can. And then some other person that the law itself recognizes as people who can actually bring any action against the Electoral Act itself. Now, the man that went to court, the court held, had no locus because, one, he wasn't an aspirant to any political office, and then he does not fall within the purview of the law that the law requires, those that actually will bring any action against the Electoral Act itself. So he doesn't fall within that ambit. Now, the court decided now to handle and give a decision on the merit. What is actually the position of the court with regards to that particular section, which says for you to contest an election as an appointee of any of the executive, you have to resign. Not as required by the Constitution. The Constitution says 30 days. But this particular act is saying at any point in time you indicate interest that you want to contest any elective position. When you are an appointed person, you have to resign. Now, the court now decided that matter on merit and said that that particular provision, and that section 84, subsection 2, is clearly at variance with the provisions of the Constitution, and so is unconstitutional. And the position of the law is that if there is any act that is enacted by the National Assembly that runs contrary to the express provision of the Constitution, that particular law or that particular section or that particular provision of the law will be regarded null and void to the extent of its inconsistency with the provision of the Constitution. And so what has happened is that the Court of Appeal has actually upheld the view of the High Court in Umuahia. The only difference the court made in that decision is to say that the man who came to court in the first place has no locus. So he had no right to have even initiated the case in the first place. But let's decide the matter on merit and look at the provision of that law, whether it qualifies as a law that is clearly consistent with the provision of the Constitution. And the court held to the contrary, that that law is contrary to the provision of the Constitution. And to that extent, it cannot stand.
Now, which then leads to the next question of with the 2023 general election just months away. Now, what does this development mean for political appointees, especially after President Buhari's order to ministers with political ambitions in his cabinet to resign by May 16th? Now, what would you make of this?
I am sure that the president made that particular pronouncement based upon the uncertainty of the law. Remember that this matter is pending before the Court of Appeal. And the president is also being careful not to allow those who may have some level of political ambition, to lose out at the end of the day if the Court of Appeal reaches a contrary decision. And so he also finds it very a bit worrying worrisome that some of them who are actually going for political position are still sitting tight, contrary to majority of the opinion of various persons that they ought to resign. So to give room, not allow certain persons to be disqualified at the end of the day when a decision is reached contrary by the Court of Appellate Court. And that may be the reason why the president said, look, if you are really ambitious for any political position, why don't you, let go of the appointment you have presently and go and pursue your political career and all that. That's why he has given them time. But I'm not sure he was probably aware of this decision that was reached later in the day. So I don't know whether the government will come up with another position. But the present position of the law, as I speak, is that if you are an appointee of the government and you want to pursue any political ambition in the present dispensation, according to the Constitution, you have only 30 days within which to resign before you can pursue your whatever you want to pursue. That is what the Constitution says, 30 days before the election. So whether the president will now modify that directive he has given through the minister today, or he will stick to that order that they should resign on or before Monday, is something that is within the realms of speculation. But I don't know what will be the outcome of whatever later decision will be taken in this matter. But as I said earlier, the president is doing this because he doesn't want to create confusion. We are not too sure what the Court of Appeal will reach as a decision. Now that the Court of Appeal has said that it's clearly unconstitutional for Section 84 to be a law enacted by National Assembly, I don't know whether they will change their mind. And that is the position of the law now, that that particular law has actually been nullified.
Well, all right. Now, Monday Ubani, legal practitioner, thank you for joining us on the news and for your contributions.